everyone. Today I will be talking about the plea bargaining process in the U.S. legal system. Plea bargaining is a process where defendants plead guilty for either a lesser charge or a shorter sentence. While this presentation is focused on the plea bargaining system in the U.S., it is notable that plea bargaining varies all throughout the world. It's very different everywhere. My goal today is to critically analyze the plea bargaining system from multiple perspectives and explore its benefits, drawbacks, and ethical considerations. What is plea bargaining? There are three main types of plea bargaining. The first is charge bargaining, where the defendant pleads guilty to a less severe charge. Second, sentence bargaining, which is an agreement on a lighter punishment. Third, count bargaining, in which some charges are dropped for others to be pleaded guilty to. The process involves negotiations between the prosecutor, defense attorney, and sometimes the judge's input is in there too. Offers are formalized in writing and plea hearings to ensure the defendant understands the plea and enters it voluntarily. As Bibas writes, plea bargaining is essential to the functioning of the American criminal justice system. Again, these are, as Bellin states, the uncertainty inherent in plea bargaining can lead to both under and over punishment, which is why some people don't really like it. The plea bargaining process. Negotiation between prosecutor, defense attorney, and sometimes the judge, formalized through plea agreements. Plea hearings ensure defendants understand terms and voluntarily agree. Outcome becomes binding, and once it's approved by the court, it's locked in. As Capers states, prosecutors have significant discretion in deciding which cases to offer for plea bargaining. Pros of plea bargaining. Efficiency. It reduces backlog in the courts and saves time and resources. Lesser penalties. This may lead to more lenient sentences. Certainty avoids unpredictability of trials. According to Ortman, plea bargaining provides certainty for both prosecution and defense, allowing cases to be resolved efficiently. The cons of plea bargaining. Innocent pleas. Defendants could plea to charges that they haven't actually committed for a lesser sentence. And they do that to avoid harsher trial outcomes. Inequality. Legal outcomes often depend on quality of their representation. Public perception. Justice may appear compromised for speedier trials. According to Oshler, this system is nearly perfectly designed to convict the innocent. A case study, a real example, is the case of Alford pleas. The defendant maintains innocence but pleads guilty for reduced sentence. It highlights pressures defendants face even when innocent, and it demonstrates tension between efficiency and fairness. The analysis of the case. Pros: court efficiency, predictable outcomes, and reduced punishment. Cons: risk of wrongful convictions, potential coercion, and disparity in representation. Some ethical questions are: should courts allow pleas from those who maintain innocence? And from Alsher, he quotes that almost every defendant may find it advantageous to plead guilty, whether guilty or innocent. Some ethical considerations are that defendants' autonomy versus pressure to plead. Attorneys' influence may prioritize convenience or fees over client interests. Courts must balance fairness, efficiency, and justice. My conclusion in our future directions. Plea bargaining. It is essential but ethically complex. System pressures can disproportionately affect innocent or vulnerable defendants. Suggested reforms are to increase the transparency of deals, to ensure defendants fully understand rights and consequences, and to explore alternatives to minimize coercion. And these are my references.